Hello, I'm Brad Augustine here with Dan Hollander from Hollander and Loan. We're talking today about a whole host of different subjects on the idea of asset protection. Before we get started, I wanted to remind you that this is part of our resident training series, but really this is applicable to any physician in any stage of their training, and even those that might not even be physicians as well. We'll talk today in a number of different sections, starting off with some more anecdotal ideas of how to just protect yourself without doing any sort of complex planning. Something that we see a lot is people who are engaging in behaviors as physicians that are just making it far more likely for them to become targets. The fact of the matter is, as a physician or a dentist, you're in the most likely category of getting sued. And that's not just in your operating rooms and for malpractice claims, etc. That's just in day-to-day life. The reality is, with today's world, all it takes is a grievance and a quick Google search, and somebody sees behind your name the letters MD, DO, DDS, whatever that might be, and you become an instant target. They will associate that with a lot of money, regardless of whether you have it or not at this point in your career. They will go after it. If you don't have the money that they're going after, they can go after your future earning potential. So we just wanted to talk about a few tips and tricks today, going through what we can do to make you less of a target, and then if you already have become a target, or if you still get sued anyway, what you can do to protect some of those assets. I was talking with Dan this morning about a story where we had a client that was showing up late to a meeting. They were never late for a meeting. I waited for a period of time and then figured they had forgotten. I couldn't get a hold of them on their cell phone, and so I went down to the parking lot, and they had actually just gotten involved in a car collision in the parking lot. And it was a minor fender bender thing. But that's when I saw that it was an orthopedic surgeon, that his license plate said Bone Doc on it. There are a lot of issues with this story, not the least of which is by having Bone Doc, you are just begging for a lawsuit. So, Dan, if you could talk a little bit about some of the ways that you've seen physicians act that would be just making it more likely for them to be a target.
Sure, Brad. The reality is that once you are done with your training and start your practices, you're going to start living your lives differently than you were when you were not making the money that will come to you by negotiating a good contract. And you should check out our blog on negotiating contracts as well. But when you're in a practice, the types of your lifestyle is going to be redefined, so that if you're driving an expensive car, or if you acquire a speedboat, there are risks attendant to those, and there are a host of. We had someone that ended up acquiring a speedboat and was on a small lake, and they ended up hitting a jet ski that was weaving in and out. It was the jet skier's fault, but we're in a no-fault state, and it's still required to the insurance companies. In this instance, the claims were paid. It was that no one died in it, but if someone had died, there could have been other issues that emerged that could go, and that would be due to a claim exceeding the limits of your property and casualty policy. So what we typically recommend is that you understand that as you were pointing out, you're a deep pocket when you're a physician, and that attorneys are going to take that into account. When they're approached by someone who's been injured, whether it's in their office, whether it's on the sidewalk in front of the physician's home, in their car, on their speedboat, and that frames the conversation as to what type of things do you need to do to protect the investment that you've made in your education and the future income that you're going to have.
Well, one thing that just comes to mind immediately with this that we always recommend for everybody, physician or non-physician, is the idea of an umbrella policy. So an umbrella policy is a really simple, it's property and casualty style of insurance. So whomever is the one that does your home and auto policy, you can just contact them and say, I'm interested in an umbrella policy, and they'll know exactly what you're talking about. What an umbrella policy does is it takes your liability limits, and I'll have Dan talk a little bit more about what that liability style of protection is, but it just increases them significantly for a really low cost. Can you talk a little bit more about that, Dan?
Yeah, before I do, just use the metaphor of umbrella and imagine that that umbrella can be carried wherever you go. So whereas you insure your home, it's a fixed, delineated structure on a piece of property. But if you're asking your property, and it's actually relatively cheap.
$100, $200 for every $1 million of coverage.
It's not expensive insurance.
Yeah.
But you take that umbrella, and wherever you walk, whether you're in your neighborhood, whether you're on your boat, that coverage, additional coverage, will be present. And so that the umbrella concept it simply means it's mobile coverage.
The one exclusion would be in your practice. So anything that you're doing work related is not covered by the liability protection for your umbrella policy.
There is a notion that some physicians who we meet with have, that they are protected in their practice because they have a professional limited liability company. That is inaccurate. The fact is that a court can always pierce the corporate veil, that is the technical term, if there is a malpractice. And that's true for any type of professional expertise. So even though we have an LLC, if we were to commit malpractice, we could be sued in some way, and that implies that it could actually touch our personal assets.
Yeah.
That's why physicians, particularly new physicians, if you're coming out of your residency or fellowship, should be clear in your contract negotiations as to what type of med malpractice insurance the practice is offering, and if they don't have what you need to pick up, because that's not cheap insurance, and it's there are limits to all contracts. And what the umbrella policy, going back to Brad's point, does is creates an additional layer.
Yeah.
Whether it's $2-3 million, it's not expensive insurance. It's rarely tapped, but important that you look at the limits of your med mal, the limits of your property and casualty, and to discuss with your insurance agent, is the insurance sufficient?
Yeah, one thing I always say when talking about an umbrella policy is, let's just use the amount of $1 million. So you're getting an additional $1 million of liability protection. The thing I always say is that's the first $1 million that somebody is suing you for. So if somebody's suing you for, $2 million, the first $1 million comes from that policy. And I always say that insurance companies have far better lawyers than you could ever find on your own. So they will do anything to prevent giving out that $1 million, which keeps hopefully the rest of the lawsuit in check as well. One thing I wanted to piggyback off of, when you were talking about malpractice insurance, there are two main types of malpractice insurance. And I'm sure most of you are already aware of what those are, but I just wanted to really quickly go into those. There's claims made, and there's occurrence policies. And the names actually kind of make it clear what they are, but let's say you're working for a practice for a period of 2 years, and then you leave that practice and go someplace else. During the tenure of your time at that first practice, you have in this case, we're going to say a claims made policy. So what that means is, let's say on day one, you do something wrong, or you're just in the OR getting coffee and you get brought into a lawsuit, whatever it might be. So that happens then. A year later, you get sued for that occurrence or when that happened. because you are still at that practice, in that claims made policy, you're covered because the claim was made while you were in that 2-year period. Now, let's say that you leave that practice and go someplace else. You leave that claims made policy behind. That person doesn't sue you for 4 years after the actual occurrence of the malpractice. Well, unless you have certain amendments to your policy, you do not have coverage. The amendments to that policy is called tail coverage. Tail coverage will then, when you go to your next practice, cover your tail, so already cover what was left behind. So that's claims made policy. Occurrence-based coverage is for when the malpractice occurred. So using our example again, if you had your issue on the first day and then you were sued 1 year later, you're covered because it was when you had the coverage was during the occurrence of when that coverage was occurring. And then if it happened 4 years in the future, you're still covered because of when the actual action occurred. So that's important to remember. You always need to have either occurrence coverage or claims made coverage with tail coverage as well. The final thing I'll say on that is oftentimes if you're switching to another practice, one of the things that you can talk about the new practice covering is your nose, which is the tail from the prior practice. So oftentimes, and again, I'll pitch again our contract negotiation blog that we did, but you can have them cover the cost of, which can be quite costly, your tail coverage, and they call that nose coverage. Anything to add to that, Dan?
No, I think that it may be useful at this juncture to talk about things other than insurance that can assist you in being able to look at ways to mitigate the risk.
Yeah, so let's take a quick break, and then we'll get to that next topic.
Okay, very good, thanks.